Judgment in the matter of the Queen versus TRA.
Before I ask Lord Lloyd-Jones to explain the court's decision, I should say that the court has ordered, under the Contempt of Court Act 1981, that no one shall, until the completion of the criminal proceedings against the appellant, publish or reveal the name of the appellant, or publish or reveal any information which would be likely to lead to the identification of the appellant in connection with these proceedings. And apart from that, Section 37, subsection 1 of the Criminal Procedure and Investigations Act 1996 shall not apply to the report of this appeal. I shall now ask Lord Lloyd-Jones to explain what it's all about.
The United Nations Convention Against Torture entered into force in 1987, and currently 166 states are parties to the convention. In Article 1, it creates an offence of torture, one of the necessary elements of which is that it is committed by or at the instigation of, or with the consent or acquiescence of, a public official or other person acting in an official capacity. Every state which is a party to the convention agrees to take measures to prevent acts of torture, so defined, in its jurisdiction, and to ensure that all acts of torture, so defined, are offences under its criminal law. The Convention leaves the prosecution of torture to the contracting states, which all undertake to bring prosecutions in defined circumstances. The United Kingdom is a party to the Convention, and the Convention is given effect within the law of the United Kingdom by the Criminal Justice Act 1988. The definition of the offence of torture in that statute reflects the definition in the Convention. Once again, it is a necessary element of the offence that it be committed by a public official or a person acting in an official capacity. This appeal is about when a person is acting in an official capacity. The appellant, TRA, who was arrested in the United Kingdom on the 1st of June 2017, is charged with 1 count of conspiracy to commit torture and 7 counts of torture. The charges relate to events in Liberia in 1990, in the early stages of the First Liberian Civil War, when an armed group, the National Patriotic Front of Liberia, NPFL, led by Charles Taylor, sought to take control of the country and to depose the then President Samuel Doe. The NPFL eventually succeeded in taking control of Liberia, and Charles Taylor became president in 1997. The appellant denies any involvement in the alleged offences. The prosecution maintains that at the time and place of the alleged offences, the NPFL was in fact the military government or government authority, and that Charles Taylor and those acting with him, including the appellant, were acting in an official capacity on behalf of the NPFL and had effective control of the area where the various alleged offences occurred. On behalf of the appellant, it submitted that the term person acting in an official capacity applies only to those acting for or on behalf of the government of a state. As a result, the appellant submits, the offence of torture cannot be committed by an alleged member of an armed opposition group fighting against or seeking to overthrow the government of a state, as was the NPFL at the relevant time. The appellant applied to dismiss the charges. On that application, Mr. Justice Sweeney held that the offence applies not only to those acting for entities either tolerated by or acting under the authority of the government of a state, but also, in situations of armed conflict, to individuals who act in a non-private capacity and as part of an authority-wielding entity. He concluded that there was a case to answer on all counts. On appeal to the Court of Appeal, that court ruled that a public official or person acting in an official capacity is not confined to those acting on behalf of a recognized state, but covers any person who acts otherwise than in a private and individual capacity for or on behalf of an organization or body which exercises or purports to exercise the functions of government over the civilian population in the territory which it controls, and in which the relevant conduct occurs. Furthermore, it covers any such person, whether acting in peacetime or in a situation of armed conflict. TRA now appeals to this court with the permission of the court. By a majority, Lord Reed dissenting, the Supreme Court substantially agrees with the conclusion of the Court of Appeal, but because of further evidence from the prosecution's expert, which was produced after the judgment of the Court of Appeal, it allows the appeal to the limited extent of remitting the matter to the judge for further consideration in the light of that further evidence and the judgment of the court. The majority considered that the prosecution is correct in its interpretation of the provisions, which is supported by the ordinary meaning of the words in their context and in the light of their object and purpose. They consider that torture perpetrated on behalf of a de facto governmental authority is a matter of proper concern to the international community and within the rationale of the Convention scheme. The majority explain why the appellant's suggested reading in Article 1 gives rise to a number of anomalies concerning issues of recognition of states and governments. The majority conclude that the offence applies without distinction between recognised and unrecognised states, similarly resort to state practice in the recognition or non-recognition of governments is incapable of providing a uniform standard by which the Convention can be applied. The majority conclude that a person acting in an official capacity within Section 134 of the Criminal Justice Act 1988 includes a person who acts or purports to act otherwise than in a private and individual capacity for or on behalf of an organisation or body which exercises in the territory controlled by that organisation or body and in which the relevant conduct occurs, functions normally exercised by governments over their civilian populations. Furthermore, it covers any such person, whether acting in peacetime or in a situation of armed conflict. In coming to this conclusion, the majority distinguished the exercise of governmental function from purely military activity not involving any governmental function. In any given case, it will be necessary to look at the position on the ground and to consider whether, at the relevant time, the entity in question had a sufficient degree of organisation and actual control over an area, and whether it exercised the type of functions which a government or governmental authority would exercise. Furthermore, the continued existence of a central government would not prevent an entity exercising such authority from being a de facto government in respect of the territory under its control.